Very good morning, all the friends and participants who are watching this video. Let us try to study the subject of cross-border insolvency in Malaysia. I hope my screen is visible. So, here, this Cross-Border Insolvency Act, it got the royal assent on 20th of January 2026. Wide Gazette notification dated 30th January 2026. But it is not yet in force because commencement date is yet to be notified by the minister in Gazette. But let us study this Cross-Border Insolvency Act because it could be, this commencement date could be notified anytime soon. So, first of all, we'll try to understand the background and historical context. Then the UNCITRAL model law, origin and principles, structure of this act, which is divided into 6 parts. Part 1 is preliminary. Part 2 is access of foreign representatives and creditors. Part 3 deals with recognition of foreign proceedings and relief and effects of recognition. Part 4 deals with cooperation with foreign courts. Part 5 deals with concurrent proceedings. Part 6 deals with general powers and schedules. Besides this, I have included some key flowcharts also regarding recognition and relief process. With reference to India, what is the cross-border insolvency framework? And I have done a comparative analysis also of India versus Malaysia, right? And at the end, we'll see some practical tips. So let us go to study this subject, which is relatively new and it could be in force anytime soon. So why cross-border insolvency law? As you know, it is the modern day reality that modern corporations operate across multiple jurisdictions. They have got assets, employees, and creditors spread worldwide. But domestic insolvency laws stop at national borders. So there is a chaos when a multinational becomes insolvent. How to proceed with it? So there is a legal vacuum. And without coordination, creditors race to seize assets in individual jurisdictions, destroying value. So a need is felt for internationally harmonized rules which protect all stakeholders and promote business rescue. Now let us see the historical context from common law to codified framework. Let us try to understand the journey of Malaysia. So Malaysia relied on common law principles and bilateral treaties, and there was no unified statute on the subject. But Malaysia modernized its corporate law, recognized need for cross-border framework. This is based on 1997 UNCITRAL model law, wherein the UN adopts the model law on cross-border insolvency, and 30 plus countries have already adopted it. Now we come to January 2026, where this Act 877 is enacted. So Cross-Border Insolvency Act, it got the royal assent on 20th of January and it was notified in the Gazette on 30th January 2026. But it is yet to come into force. So Section 1, Subsection 2, commencement shall be by ministerial notification. So this has Act 877 has received royal assent and been gazetted but is not yet operative law. So Section 1, Subsection 2, it says this act comes into operation on a date to be appointed by the minister by notification in the Gazette. Let us see the journey. Passed by Parliament early January 26, royal assent on 20th January, publication in Gazette 30th of January, ministerial notification pending as of June 2026, and Act comes into force, date is yet to be notified. So what is the practical implication? Until the minister notifies the commencement date, Act 877 has no legal effect. Cross-border insolvency is still governed by the existing framework. Now, what is the current law in force regarding cross-border insolvency? So what is the pre-Act 877 scenario? So what governs cross-border insolvency in Malaysia as on date? So as of June 2026, Act 877 is not yet operative. The cross-border insolvency in Malaysia is still governed by a patchwork of existing statutes, common law, and judicial discretion. Let us try to have a look at some of the laws. We have already done a lot of videos on Companies Act and Insolvency Act. So Companies Act 2016, which is Act 777, it deals with winding up of foreign companies with assets or operations in Malaysia. Then judicial management. Malaysian courts can appoint judicial managers over local companies. Corporate voluntary arrangement and scheme of arrangement, local proceedings only, and no provision for recognizing foreign insolvency orders or automatic moratorium on foreign proceedings. So this is the position as per Companies Act 2016. Now let us go to Insolvency Act of 1967. It governs personal or individual insolvency in Malaysia, not corporate insolvency, which is governed by Companies Act 2016. No cross-border recognition mechanism, so foreign bankruptcy orders are not automatically recognized. And this Act 877 explicitly excludes individual insolvency under Act 360 from coming its future scope as well, right? Now, Common Law and Courts of Judicature Act 1964, Act 91. So, principle of modified universalism operates. So, Malaysian courts may give committee-based recognition to foreign insolvency orders at their discretion. No statutory obligation. So, it is purely discretionary and courts assess each case on its merits. Foreign liquidators or receivers may apply to High Court but have no automatic right of access. And civil procedure rules and inherent jurisdiction of High Court used to coordinate foreign proceedings on case-to-case basis. Now, what is the position as per Rule of Court 2012 and Order 69, which is related to arbitration? No dedicated cross-border insolvency rules in Rules of Court 2012. Letters, rogatory process through diplomatic channels for obtaining evidence or cooperation from foreign courts, and this is naturally slow and cumbersome, and no equivalent of Section 25 Act 877 direct court-to-court communication. So this is the position as of now. Now, what are the objectives? So there are 5 legislative objectives of this Cross-Border Insolvency Act 877. Preamble to the Act. What preamble to the Act says? It says that it tends to promote cooperation between courts and competent authorities in Malaysia and foreign states. It creates greater legal certainty for trade and investment across borders. It ensures fair and efficient administration of cross-border insolvencies, protecting creditors, interested persons, and the debtor. It protects and maximizes the value of the debtor's property and facilitates rescue of financially troubled businesses, protecting investments and preserving employment. So this is the preamble. Now, UNCITRAL model on cross-border insolvency, because UNCITRAL model is the base on which all the cross-border insolvency laws are based. So, International Foundation of Act 877. So, UNCITRAL model is the international foundation of this Cross-Border Insolvency Act 877, which was adopted by UNCITRAL on 30th May 1997. UN approved the UNGARS on 15th of December 1997. So, how many countries adopted it? 60 plus countries have adopted it globally over a period of time. And the core principle is there is a concept of modified universalism. So, there should be a coordinated approach while handling insolvencies which are spread over multiple jurisdictions internationally. So what are the key features of the UNCITRAL model law? It provides a uniform framework for states to enact their own cross-border insolvency legislation. It is not a treaty. Each state adapts it through domestic legislation with local modifications. It focuses on recognition of foreign proceedings, relief, cooperation, and concurrent proceedings. There are 4 key pillars to this UNCITRAL model. access of foreign representatives, recognition of foreign proceedings, and relief and cooperation. And Malaysia's Act 877, it closely follows the model law. Its preamble explicitly states adoption of UNCITRAL principles. Section 2, subsection 2 says, in interpreting this act, regard shall be had to its international origins and the need to promote uniformity. Now, what are the four pillars of this UNCITRAL model law? This is very much mirrored in Cross-Border Insolvency Act of Malaysia 877. Number one is the access. So foreign representatives have right of direct access to local courts. Second is recognition. Local courts must recognize foreign main and non-main proceedings. Third is relief, automatic relief upon recognition. So discretionary additional relief available. And fourth is cooperation. So direct communication between courts and insolvency practitioners across borders. Now, let us see the scenario of global adoption of UNCITRAL model law. So there are 60 plus jurisdictions and it's a growing network. Asia Pacific, Malaysia adopted it in 2026 by virtue of this Act 877. Singapore, Japan, South Korea, Australia, New Zealand. Americas, USA, Canada, Mexico's, Brazil, Colombia, Europe, UK, Poland, Romania, Serbia, Slovenia, and Africa and others, South Africa, Kenya, Malawi, and Uganda. So these are the jurisdictions where this UNCITRAL model law has been globally adopted. Now, what is the legal basis? What is the legislative basis of this Cross-Border Insolvency Act of Malaysia 877? Whether it is based on UNCITRAL model law or whether it is based on UK law. So what is it based upon? So Act 877 is directly and explicitly based on the UNCITRAL model law on cross-border insolvency. It is not based on any specific law, right? Why UNCITRAL? Because it is given in the preamble of the Act itself. The preamble states verbatim, expedient to provide for matters relating to cross-border insolvency in accordance with the principles of the model law on cross-border insolvency adopted by UNCITRAL dated 30th May 1997 that was approved by the General Assembly of the UN on 15th December 1997. So section 2 subsection 2 says courts must have regard to Act 877's international origins and need for uniformity in its application, enabling use of UNCITRAL explanatory notes and foreign judgments from other UNCITRAL jurisdictions. So this makes Malaysia part of the global UNCITRAL network of 60 plus jurisdictions, including Singapore, USA, UK, Australia, Japan, etc. The choice of UNCITRAL as basis reflects Malaysia's policy to harmonize with international trade and commerce norms. So UK adopted the same UNCITRAL model law as the Cross-Border Insolvency Regulations 2006. So both Malaysia and UK derive from the same source, not Malaysia from UK, right? Now let us try to understand the structure of this Cross-Border Insolvency Act, which is divided into 6 parts. And what are the 6 parts and 35 sections? Part 1 is preliminary, which deals with the definitions, application, competent court, and public policy exception. Part 2 deals with access, sections 9 to 14, which says that foreign representatives and creditors' right of access to Malaysian courts. Part 3, recognition and relief, section 15 to 24, recognition of foreign proceedings, automatic and discretionary relief. Part 4 deals with cooperation, section 25 to 27, direct communication and cooperation between courts and office holders. Part 5 deals with concurrent proceedings, section 28 to 32, coordination and payment rules for parallel insolvency proceedings. And part 6 is general, sections 33 to 35, which says regulation making power, schedule amendment and saving provisions. Now, the schedule, non-application and restrictions. Who is outside this act scope? So part 1 of schedule, non-application is to 17 categories. Number 1, licensed persons under Financial Services Act 2013 and Islamic Financial Services Act 2013. So these are outside this scope. Then prescribed institutions under Development Financial Institutions Act 2002, member institutions or bridge institutions under Malaysia Deposit Insurance Corporation Act 2011, exchange holding companies, stock exchanges, derivative exchanges, clearing houses under Capital Market and Services Act 2007, and all Labuan entities, banks, investment banks, insurers, takaful operators, trust companies, foundations, payment operators, then central depositories approved under Security Industry Central Depository Act 1991. So all these are excluded. So part 1 of the schedule, non-application to 17 categories. Now part 2 of the schedule, restrictions on relief. So relief cannot be granted if it would interfere with provisions of Financial Services Act, Islamic Financial Services Act 2013 or Malaysia Deposit Insurance Act. Cannot interfere with finality of payment or netting arrangements under these acts. Cannot be inconsistent with netting of Financial Agreements Act 2015 and Central Bank of Malaysia, Securities Commission, Labuan Financial Services Authority each have veto power in systemic risk situations. Now, to whom does this Act 877 apply? So let us see the various sections. Section 2, which talks of definitions, and Section 3, which deals with application. So who is a debtor? As per Section 2, a corporation as defined in Section 3 of the Companies Act 2016, Act 777, excludes limited liability partnerships and foreign limited liability partnerships. So it's very important thing that who is a debtor? A debtor is a corporation as defined in Section 3 of Companies Act, but it excludes LLPs and foreign LLPs. So this is a very important point to remember. Or a corporation as defined in Section 2 of Labuan Companies Act 1990. So a debtor will not include LLPs and foreign LLPs. Now situations where Act 877 applies. Section 3, subsection 1. Assistance sought in Malaysia by a foreign court or foreign representative in connection with foreign proceedings. Assistance sought in a foreign state in connection with Malaysian for insolvency proceedings. Foreign proceedings and Malaysian insolvency proceedings in respect of the same debtor are concurrent, and foreign creditors have an interest in applying for or participating in Malaysian insolvency proceedings. So please remember that insolvency proceedings could be taking place in Malaysia or in foreign courts. So Section 3, subsection 1 explains all these situations. Number 1, assistance sought in Malaysia by a foreign court or foreign representatives in connection with foreign proceedings. So number 1 deals with where the foreign proceedings are taking place, right? And assistance is sought in Malaysia. Second is assistance sought in a foreign state in connection with Malaysian insolvency proceedings. Third is foreign proceedings and Malaysian insolvency proceedings in respect of the same debtor are concurrent. And fourth, foreign creditors have an interest in applying for or participating in Malaysian insolvency proceedings. So these are the various situations where this Act 877 applies. But it does not apply to individual insolvency under Insolvency Act of 1967, on which we have made a separate video, and persons carrying on registered or licensed businesses, limited liability partnerships, and entities in the schedule. Now let us see the language. Let us try to understand the language of Act 877. What are the key definitions? Number 1, foreign proceedings. So collective, judicial or administrative proceedings in a foreign state, including interim proceedings under insolvency law, in which the debtor's property and affairs are subject to control or supervision by a foreign court for reorganization or liquidation. So what are foreign proceedings? These are collective, judicial or administrative proceedings in a foreign state, including interim proceedings under insolvency law, in which the debtor's property and affairs are subject to control or supervision by a foreign court for reorganization or liquidation. Now, foreign main proceedings. So foreign proceedings taking place in a foreign state where the debtor has its center of main interest, COMI, right? And foreign non-main proceedings. So foreign proceedings other than main proceedings where the debtor has an establishment, non-transitory economic activity in the foreign state. Foreign representative. Foreign representative is a person or body appointed, including on interim basis and authorized in foreign proceedings to administer reorganization or liquidation or to act as representative of those proceedings. Establishment. Any place where debtor has property or any place of operations where debtor carries out a non-transitory economic activity with human means and property or services. Now, this Malaysian insolvency office holder. So, who is this Malaysian insolvency office holder? Official receiver, liquidator, judicial manager, nominee, supervisor of CVA, representative of scheme of compromise or arrangement under Companies Act or Labuan Companies Act 1990. So these are the key definitions which are given in section 2. Now what is this COMI versus establishment? Center of main interest and establishment. So this is a critical distinction between these two. Center of main interests. It leads to foreign main proceedings. Section 16, subsection 3 says it is a rebuttable presumption. So debtor's place of registered office is presumed to be the COMI unless contrary evidence is produced. So automatic effects are on section 19, stay of individual actions, stay of executions and suspension of disposal rights. So the scope is the same as winding up order under Companies Act 2016. Whereas establishment, it leads to foreign non-main proceedings. The definition, any place where the debtor has property or where the debtor carries out non-transitory economic activity with human means and property or services. So only discretionary relief can be provided in case of establishment and court must be satisfied that relief relates to property to be administered in non-main proceedings or information required in non-main proceedings. So there is no concept of automatic moratorium in case of establishment. Now, what are the safeguards regarding public policy, office holder powers and other laws? Section 4 to 8. So section 4 says that act to be read together. So Act 877 shall be read together with all other written laws relating to insolvency. Its provisions are additional to and not in derogation of other insolvency laws. Section 5. Competent court. The High Court in Malaya or the High Court in Sabah and Sarawak as applicable has exclusive jurisdiction over recognition of foreign proceedings and cooperation functions under this Act. Section 6 says authorization to act abroad. A Malaysian insolvency office holder is authorized to act in a foreign state on behalf of Malaysian insolvency proceedings as permitted by that state's law. Court may also appoint another person for this purpose. Now section 7. Public policy exception. The court may refuse to grant any order or relief if doing so would be contrary to the public policy of Malaysia. This is a broad discretionary safety valve and absolute override. Section 8 says additional assistance. Nothing in Act 877 limits the powers of the court or a Malaysian insolvency office holder to provide additional assistance to a foreign representative under other written laws of Malaysia. Now part 2, which deals with access of foreign representatives to Malaysian courts. Section 9 deals with right of direct access. So foreign representative can apply directly to the court. No need for a Malaysian liquidator as intermediary. It can appear in person or through an advocate. Advocate means any person entitled to practice in any part of Malaysia. Section 10 talks of limited jurisdiction. Mere filing of application does not subject to foreign representative or debtor's assets to Malaysian court's jurisdiction for any other purpose. So this protects the foreign representative from inadvertently submitting to Malaysian jurisdiction. Now section 11, right to commence proceedings. A foreign representative from main or non-main proceedings can apply to commence proceedings under Malaysian insolvency law, subject to meeting the usual conditions for commencing such proceedings. Section 12, right to participate. Once foreign proceedings are recognized, the foreign representative may participate in Malaysian insolvency proceedings regarding that data, and it gives them full standing in local proceedings. Now let us see the foreign creditors, sections 13 and 14. So equal treatment and notification rights. So section 13 says equal rights for foreign creditors. So foreign creditors have the same rights as Malaysian creditors regarding commencement of and participation in Malaysian insolvency proceedings. Exception is it does not affect the ranking of claims. Local priority rules still apply. Specific exclusions from proceedings, foreign tax claims, social security claims, employee superannuation, provident fund claims. Right? So these are specifically excluded. Key protection. Section 13, subsection 3. A foreign creditor's claim shall not be ranked lower than general unsecured creditors solely because the creditor is foreign. Right? So section 14. Notification to foreign creditors. When notification is required to creditors in Malaysia, it must also be given to all known foreign creditors without Malaysian address. Individual notification by default, court may allow other forms, electronic, online, newspaper advertisement in foreign newspapers. Notification of right to file claim must specify a reasonable time period and place for filing, whether secured creditors must file and other statutory requirements, and court may order reasonable steps to notify foreign creditors whose addresses are not yet known. Now part 3, it deals with recognition, application process. Section 15, how to apply for recognition. Who can apply? Foreign representative appointed in foreign, main or non-main proceedings. Section 15, subsection 1 deals with this. And what are the documents required with application? Section 15(2), there are various alternatives. Option A is that along with the application, you attach certified copy of the decision commencing the foreign proceedings and appointing the foreign representative. Option B is you attach a certificate from the foreign court affirming the existence of the proceedings and the appointment. And option C, in absence of A and B, any other evidence which is acceptable to the court, you can attach along with the application. And also required along with the application is the statement identifying all foreign proceedings and Malaysian insolvency proceedings regarding the data known to the foreign representative. And section 15, subsection 4, it says translation into English of non-English documents with a certificate of accuracy from the translator. Now section 16. Section 16 talks of the presumptions. If decision or certificate indicates foreign proceedings and foreign representative, court is entitled to presume this. Right? So court may presume documents are authentic even without legalization. And in absence of contrary proof, debtor's place of registered office is presumed to be Qawmi. Right? Yes. Recognition decision. Section 17. When must the court recognize? So by way of a flow chart, let us try to understand this scenario. So once application is filed under section 15, so what is to be decided? Are proceedings foreign proceedings under section 2? Second, does application comply with section 15 and 2 and 3? Yes to all the 4 conditions, then court shall recognize subject to section 7. If an application is filed under section 15, is the applicant a foreign representative? Under section 2, it is submitted to the correct high court, not no to any condition, then application is rejected or further evidence submitted. Right? So this is the process of recognition by courts. Now, what are the types of recognition and modification or termination? Foreign main proceedings. So foreign main proceedings are recognized when the foreign proceedings take place where the debtor has its center of main interest. Qawmi. What is the effect? Automatic stay of individual actions, automatic stay of executions, and automatic suspension of disposal rights. Additional discretionary relief is also available under section 21. But there is a strong protection, so mirrors winding up order effect, which is given in Companies Act 2016. In case of foreign non-main proceedings, so these are recognized when foreign proceedings take place where the debtor has an establishment in that state. The effect is no automatic moratorium, only discretionary relief is given under section 21, and court must be satisfied that relief relates to property to be administered in those proceedings or information required in those proceedings. So this is a weaker protection which has got limited territorial scope. Now regarding modifications and termination, section 17, 4 and 5. So recognition orders may be modified or terminated if grounds for granting it were lacking at the time or have ceased. Application by the foreign representative, any affected person, or court's own motion. Provisional relief, section 19. So relief is available from application filing until recognition decision. So trigger, application filed but not yet determined. Condition is relief urgently needed to protect debtor's property or creditor's interests. Section 19(1)(a). Execution stay. So staying any execution against the property of the debtor. Section 19(1)(b). Administration. Entrusting administration or realization of whole or part of the debtor's property in Malaysia to the foreign representative or a Malaysian office holder for perishable, depreciating, or at risk property. Section 19(1)(c). Other relief. Granting any relief under section 21(1)(c), D or G. Examination of witnesses, evidence gathering, Malaysian office holder powers. So what are the important limitations on provisional relief? Section 19(2) says that any provisional relief must be consistent with other orders that have been or may be made under Act 877 or Companies Act 2016, Labuan Companies Act 1990, or other written laws. Section 19(3). Unless extended under section 21(1)(f), provisional relief terminates upon the determination of the recognition application. Section 19(4). Courts may refuse provisional relief if it would interfere with the administration of foreign main proceedings. Now, what is the effect of recognition? Foreign main proceedings. Section 20. The automatic moratorium. Upon recognition as foreign main proceedings, what are the automatic effects? Stay of commencement or continuation of an individual action relating to debtor's property, rights, obligations, or liabilities. 21(b). Stay of any execution against debtor's property. 21(c). Suspension of right to transfer, encumber, or otherwise dispose of debtor's property. So scope is same as winding up order under Companies Act 2016. Right. Now exceptions. So despite stay, what is not affected? Security enforcement. Right of any person to enforce any security over debtor's property. This is not affected. Hire purchase. Rights to repossess goods under Hire Purchase Act are not affected. Regulatory functions. Rights of body having regulatory, supervisory, investigative, enforcement functions. Claim preservation. Actions to commence individual proceedings to the extent necessary to preserve a claim. Creditor set off. Right of a creditor to set off his claim against the debtor's claim. Insolvency proceedings. Right to initiate proceedings under Malaysian insolvency law or to file claims. So all these things are not affected despite the stay. Right. So section 20 subsection 7 talks of the definition of security. It says security means any charge, lien, mortgage, pledge, hypothecation, or any other security recognized by law, including any security accepted in relation to matters of admiralty in Malaysia. Now, discretionary relief upon recognition. Section 21. This is available for both main and non-main proceedings. So, court may grant the following relief on application by the foreign representative where necessary to protect debtor's property or creditor's interests. Section 21(1)(a). Staying individual actions which are not already stayed under section 20. Section 21(1)(b). Staying execution not already stayed under section 20. 21(1)(c). Suspending disposal rights not already suspended under section 20. 21(1)(d). Examination of witnesses, taking evidence, delivery production of information on debtor's property, rights, obligations, or liabilities. 21(1)(e). Entrusting administration or realization of whole or part of debtor's Malaysian property to foreign representative or other court appointed person. Section 21(1)(f). Extending any provisional relief previously granted under section 19(1) And 21(1)(g), any relief that may be available to a Malaysian insolvency office holder under Malaysian laws. So 21(2) says regarding any transfers outside Malaysia, it requires leave of the court. So it's granted only if Malaysian creditors' interests are adequately protected. Now creditors protection and avoidance sections. Section 22 and 23. Safeguards and clawback powers. Section 22. Protection of creditors and interested persons. So before granting or refusing or modifying relief under Section 19 or Section 21, court must be satisfied that interests of creditors in Malaysia, secured creditors, hire purchase parties, and other interested persons are adequately protected. And court may impose conditions on relief, including requiring foreign representative to furnish security for due performance of functions. Court may, on application of any affected party or own motion, modify or terminate relief at any time. Now, let us see Section 23, which deals with actions to avoid detrimental transactions. Clawback. Upon recognition, foreign representative has locus standi to apply under the following sections of Companies Act 2016. Sections 528 to 531 and 540 to 541 regarding transactions at an undervalue, unfair preferences, fraudulent trading or wrongful trading. Section 352 for voidable transactions, disposition of property after commencement. Section 366 regarding compromise or arrangement, clawback. Section 426 judicial management transactions. Section 472 execution / attachment avoidance. Section 20 of Labuan Companies Act 1990 ultra-virus transactions and modification. Date of opening of relevant foreign proceedings substitutes for the usual reference dates under Malaysian law. Section 23/9 does not apply to transactions before the date of commencement of this. Now let us see the cooperation part, which is given in sections 25, 26 and 27. Section 25 says that court may cooperate to maximum extent possible with foreign courts or foreign representatives. Cooperation can be direct or through a Malaysian insolvency office holder. Court is entitled to communicate directly with and request information or assistance from foreign courts or foreign representatives. So no requirement to go through diplomatic channels. Section 26 says the Malaysian insolvency office holder shall cooperate to the maximum extent possible with foreign courts or foreign representatives, but it is subject to supervision of the court. And office holder also entitled to communicate directly with foreign courts or foreign representatives, but it must exercise functions under Malaysian laws throughout. Now section 27, what could be the forms of cooperation? Appointment of persons to act under court direction, communication of information in any manner, coordination of administration and supervision of debtors affairs, approval / implementation of any agreement or coordination of concurrent proceedings on the same debtor. So these could be the various forms of cooperation. Now sections 28 to 32, concurrent proceedings. When multiple proceedings run in parallel. Section 28, it says limiting Malaysian proceedings after recognition. So after recognition of foreign main proceedings, any Malaysian insolvency proceedings on the same debtor are limited to property located in Malaysia and other property that should be administered in Malaysian proceedings for cooperation or coordination purposes. Section 29, coordination of concurrent proceedings. If Malaysian proceedings are pending at the time of recognition application, any relief must be consistent with them. Section 20, automatic stay does not apply if foreign proceedings are main proceedings. If Malaysian proceedings commence after recognition, existing relief is reviewed and modified or set aside if inconsistent. I would try to prepare a flow chart also on all these sections for easy understanding purpose. Section 30, multiple foreign proceedings. If more than one foreign proceeding concerns the same debtor, relief for non-main proceedings must be consistent with foreign main proceedings. If foreign main proceedings recognized after non-main, existing relief is reviewed and modified or set aside if inconsistent. Section 31, presumption of insolvency. Recognition of foreign main proceedings is proof that the debtor is unable to pay its debts within the meaning of Malaysian insolvency law. for the purpose of commencing Malaysian proceedings, but it is rebuttable by contrary evidence. Section 32. Rule against double recovery. A creditor who has received part payment in foreign insolvency proceedings shall not receive payment for the same claim in Malaysian proceedings until other creditors of the same class have received proportionately equivalent payment. So without prejudice to security or in rem rights. Now let us see the provision of concurrent proceedings, section 28 to 30, coordination logic. So foreign proceedings recognized in Malaysia. Are Malaysian insolvency proceedings already pending? Yes. Then relief under section 19 or 21 must be consistent with Malaysian proceedings. But if Malaysian insolvency proceedings are not already pending, then Malaysian proceedings may commence. So section 28 limits scope to assets in Malaysia. Okay. If there are multiple foreign proceedings, then you have to identify the main and non-main proceedings. In case of non-main proceedings, relief must be consistent with main proceedings. And in case of creditors who received part payment in one set of proceedings cannot receive more until others in the same class are equally paid. So this is a brief about the concurrent proceedings decision flowchart. Part 6, General Regulations, Amendments and Saving. Section 33, it says power to make regulations. The minister may make such regulations as may be expedient or necessary for giving effect to or for better carrying out the provisions of this act, void subordinate legislation making power. Section 34, power to amend the schedule. The minister may, on the recommendation of Central Bank of Malaysia, Securities Commission Malaysia, Malaysia Deposit Insurance Corporation, Labuan Financial Services Authority, Companies Commission of Malaysia, Civil Aviation Authority of Malaysia, amend the schedule by gazette order, effective from date of publication or a later specified date. Section 35 is the saving provisions. So Act 877 applies only to proceedings commenced on or after its commencement date. So proceedings commenced before continue under old law. Past orders, rights, obligations and liabilities remain valid if not inconsistent with Act 877. Creditors' existing rights and remedies are not affected unless agreed by parties or directed by court. Now, who is a Malaysian insolvency office holder? Section 2. An official receiver. The official receiver as defined in Section 2 of the Companies Act 2016. Liquidator. Any person appointed under Companies Act 2016 to act as liquidator or interim liquidator in compulsory or voluntary winding up. Judicial manager. Any person appointed under Companies Act 2016 to act as judicial manager or interim judicial manager in judicial management. CVA nominee or supervisor. Any person appointed as nominee or supervisor of a CVA under Companies Act 2016. Scheme representative. Any person appointed as representative of a scheme of compromise or arrangement under Companies Act 2016. Labuan liquidator. Any person approved under the Labuan Companies Act 1990 as an approved liquidator. Court appointed person. Any other person appointed by the court under Section 6 subsection 2 to act in a foreign state on behalf of Malaysian proceedings, and other recognized person, any other person or body recognized under any written law in Malaysia in a collective, judicial or administrative insolvency proceedings in Malaysia. So these are the various persons who are covered under Malaysian insolvency office holder. Now, complete recognition and relief process flowchart. Section 15 to 24, end to end. So foreign representative appointed in foreign proceedings, it prepares application under section 15 and it addresses document plus English translation. It files with the High Court in Malaysia. Okay. Then court reviews. So 4 conditions of section 17 are checked and then recognition is granted, main or non-main. Okay. Then automatic stay for main proceedings and discretionary leave in both types. Right. And then creditor protection checks. Section 22, and then foreign representative participates in Malaysian proceedings. So, and provisional relief is available immediately upon filing in urgent cases. So, this is the complete recognition and relief process. Now, complete process flowchart from foreign insolvency to Malaysian recognition and relief. So, foreign insolvency opens, foreign representative appointed, seek Malaysian assistance. Section 9, direct access. You file recognition application under Section 15. Then, whether COMI is in foreign state. If yes, then main proceedings, auto moratorium. If COMI in foreign state and non-main proceedings, then limited leave. Otherwise, discretionary relief. So, this is a flow chart which deals with foreign insolvency to Malaysian recognition and relief. Section 14, notification to foreign creditors. Malaysian insolvency proceedings commenced. Notification required to Malaysian creditors. Identify all known foreign creditors. Then, do foreign creditors have Malaysian address? No, then include in notification and must also notify the foreign creditors. And individual notification is the default method. And notification must include the time period and place for filing claims and whether secured creditors must file secured claims and other statutory information. Right? Now, India cross-border insolvency. Let us try to understand the landscape of cross-border insolvency in India also. IBC 2016 and the road ahead. Insolvency and Bankruptcy Code, sections 234 and 235 are not yet notified. So, India enacted the IBC in 2016, but section 234 regarding bilateral agreements and section 235 letter of request to foreign courts, the cross-border provisions, they remain unnotified as of 2016. So, India has been consulting on UNCITRAL adoption since 2018. Recently, in the IBC code, the IBC code was amended, but it is the provisions regarding this cross-border insolvency are yet to come into force. Section 234, IBC, bilateral agreements. Central government may enter into bilateral agreements with foreign countries for enforcement of IBC provisions. No such agreement notified yet. The provision exists but remains dormant. 235, letter of request. So, courts may issue letter of request to foreign courts to assist Indian insolvency proceedings, and foreign courts are not obliged to respond, so it remains unilateral and limited. IBBI consultation. IBBI Insolvency and Bankruptcy Board of India issued a discussion paper in 2018 recommending adoption of UNCITRAL model law, but no legislation enacted yet as of June 2016. MCA bill proposed IBC amendment. Ministry of Corporate Affairs proposed IBC amendments to incorporate UNCITRAL principles. So, introduced as part Z of IBC amendment under parliamentary consideration as of 2026. So, bill as of late has been passed, but it is yet to come into force regarding the this cross-border insolvency provisions. So, I have tried to compare by way of a chart. So, you can go through these on your own. So, these are some slides which I have put for your general reference, right? So, practical tips, let us see this slide. Practical tips for legal practitioners, for foreign representatives. So, file recognition application as soon as possible. Provisional relief under section 19 is available from the date of filing. Always include a statement of all known proceedings. Omissions can cause delays. Provide certified English translations upfront. Court cannot act without them. Consider applying for an interim administration order if Malaysian assets are at risk. For Malaysian creditors, once foreign proceedings are recognized, you have standing to participate in all related Malaysian proceedings. Your claims cannot be discriminatorily ranked lower solely for being a foreign creditor. Demand adequate creditor protection conditions under section 22 if relief is being granted. If assets are being transferred outside Malaysia, ensure that section 21 subsection 2 leave of court process is followed. For Indian law practitioners, if your Indian client has Malaysian assets, file recognition of CIRP proceedings under Act 877, although it is yet to come into force, but very soon it will see the light of the day. Use COMI presumption, section 16 subsection 3 in your favor. India as place of incorporation. Monitor India's IBC amendments if UNCITRAL adopted. full bilateral cooperation becomes available, and document the establishment of your Indian client in Malaysia carefully. Even non-main recognition gives useful relief. So what are the common issues and pitfalls in cross-border insolvency and what can go wrong? So there could be commie dispute, right? So debtor argues commie is in a different state. It leads to recognition being contested, and type of recognition may change from main to non-main. So you gather strong evidence of debtor's principal place of management. A registered office presumption helps but can be rebutted. Conflicting relief orders. Malaysian relief conflicts with orders in concurrent proceedings, may be modified or set aside under Section 29. So disclose all parallel proceedings upfront under Section 15 subsection 3 and coordinate with other courts early under Section 25. Missing translation. Application delayed or rejected if non-English documents not translated, it adds to time and cost. So prepare certified English translations in advance. Appoint a suitable translator immediately upon appointment. Assets transferred before recognition. If assets were removed from Malaysia before moratorium kicks in, Section 20 stay cannot reverse past actions. So only avoidance under Section 23 may help. So file for provisional relief immediately upon application to freeze assets before full recognition hearing. Regulatory or financial sector overlap, schedule exceptions and Part 2 restrictions mean many Labuan and regulated financial entities are outside the Act 877 scope. So check the schedule carefully at the outset. If entity is regulated, approach the relevant regulator. Double dipping, creditor who received payment in foreign proceedings claims full payment again in Malaysian proceedings. Section 32 prevents this. So ensure foreign proceedings payment records are disclosed and apply Section 32 pro rata reduction. This is a quick reference summary of the various sections which we've already covered. So this was all about Cross-Border Insolvency Act, which has been recently notified, but it is yet to come into force. So it will come into force by the date to be notified by the minister. Thank you for watching this video. If you want a copy of the BEAR Act, you can request in the comment section. I hope you liked our video. If you are liking our videos on Companies Act 2016 or Insolvency Act or this cross-border, so you can leave a comment in the comment section. If you want any improvement, you can leave a comment in the comment section. Thanks for watching this video. Thank you so much.